Imagine this, striking out the word September and inserting in lieu of there for the word October. I could report that section.
We're live.
All right. We're back live, dealing with an amendment to H-145, draft 2.1 by B&H, Bryn Hare. And we're looking at two amendments to H-145. The first, Bryn, do you want to describe?
Mr. Chair, was this sent to us or?
It's on our webpage, but
on the webpage.
Can you share the page?
Sure thing.
Brendan's going to share it so everybody can see it. And then we can.
Okay.
Ooh, how's that?
That's great.
Okay. So for the record, Bryn Hare from Legislative Council. So this is draft 2.1 of the amendment to H-145. And as the committee was just discussing, this is first an amendment to Section 4 of the Justifiable Homicide Statute that includes some language from the Vermont Supreme Court cases that Attorney Thompson raised earlier. That is really kind of taken directly from those cases that are interpreting the words just and necessary in subdivision 1. So I know that when we were talking before, I said I would add this language to both 1 and 2, but I've only added it in 2 because the language just and necessary already appears in subdivision 1. And that is, the court has interpreted just and necessary to mean this highlighted language in subdivision 2, which is that the person had to have reasonably believed that they were in imminent peril and that it was necessary to repel that peril with deadly force. So I've only included it here because otherwise I think it would be redundant and it may even lead to some confusion if you included that phrase along with the phrase just and necessary. So the other question I'd like to raise before I go to the second instance of amendment is that because I'm sort of drafting on the fly here and I haven't had some time to think this through, the committee may want to go with just a repetition of this phrase just and necessary instead of the language from the Vermont Supreme Court. It would probably be good to hear from Attorney Thompson on that point as well. Just for consistency's sake. I haven't really thought it through yet, how you would want to move forward with that, if you would want to use the same language or this language that the court has used in interpreting the phrase just and necessary.
But as I look at 1, you're talking about just and necessary defense of certain individuals. In 2, you're talking about what might be just and necessary in suppressing a person committing to attempting to commit murder, sexual assault, aggravated sexual assault. And then we get into the problem of burglary. That's where I have the problem. And yeah, I certainly, if you're suppressing someone from committing murder, that is reasonable to expect that you could use.
Yeah, that makes sense to make it clear that the requirement really is that there must be some imminent peril. That does make sense to me.
So I don't know, others not being an attorney, but to me, that's why it makes sense to have it into. Anybody who wants to comment, either Julio or
so Julio Thompson, AG's office. I think the amendment that's provided on the screen here with sub 2 describing the reasonable belief standard relating to imminent peril, I think it's consistent with the court's interpretation of justifiable homicide or use of force that would result in injury to others. So I think it's fine. I think there's not, I think, great likelihood of confusion by what it's drafted here. It has, because you are identifying certain crimes that themselves may not necessarily involve significant or imminent peril, like the example I gave where someone's being pushed down. So to be robbed of their backpack may not be something that's really presenting them in significant jeopardy, and yet you wouldn't expect someone else to discharge a firearm. So I think it's helpful.
Anyone else? You want to go to the next amendment? Which is simply taking out September and inserting a new thereof October.
Oh dear. Can everyone hear me? I think my.
Yeah.
Yeah.
Okay. All right. So the next instance of amendment is just to replace September with October in the effective date section. So that would make all of the bill effective on October 1st, except for the repeal section and the effective date section, which would take effect on July 1st. And if you'll recall, that's necessary because the standards for law enforcement use of force that passed last year take effect on July 1st. So you need to repeal those on July 1st if you don't want them to go into effect.
Thank you, Bryn. Very helpful. Any committee, any comments? I think we're pretty well. I'll move the amendments. Senator Sears has moved that we amend H 145 as seen in draft 2.1. Is there any further discussion? Hearing none, all up. Peggy, could you please follow the roll?
Sure. Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. Now, is there a motion to report H 145 favorably as amended?
I make a motion, we report H 145 as amended positively.
Senator Nitka has moved that we report H 145 positive favorably as amended. Any further discussion? Okay, Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. Yes, Senator Bruce, would you like to report this again? Since you did the first version.
I wouldn't like to report it, no.
Okay.
If you assign it to me, I will, but that's my preference.
Is there anybody else who would be jumping at the bit to report this? I'll
I
do it.
suppose at some point a defense attorney should talk about what a defense attorney does, and this might be an opportunity to say that. If you don't mind that commentary being injected into the,
I do not mind that commentary, Senator Benning, and I think it would be helpful to have you report these amendments and the bill. So,
okay. Brian, if you could get me a quick summary, and Peggy, if you could get me the witnesses, please.
Yep, and Bryn, send me after you get from drafting the version.
would you go over your comments about defense attorneys with Senator Baruth before you make them?
Joe and I have
He's heard it a few times.
we have a long tradition of running things by each other, so.
That's what I was referencing. Anything else, committee? Committee, we've got a really tight schedule tomorrow on the appropriations issues. Got a number of people who asked to testify. Additionally, the Office of Child Support is really concerned that there was no mention of magistrates in the court's reopening proposal, and they have a tremendous backlog of child support cases. So we have Robin Arnell coming. We also have a real concern from the victims' advocates about the workload that they're under if we do the reopening. And the BSEA is coming and they're proposing 14 new victims advocates in the base. believe that John Campbell's going to advocate 14 new assistants. And I think those are temporary positions.
Assistant what? Assistant,
Assistants to
the advocate?
victims, the victims
state's attorney.
advocates
Or
and the
to-
state's attorneys.
14 new to the state's attorneys?
Yeah, if you think there's 14 of them. One could argue about the necessity in one particular county, but I won't mention that county.
Well,
So it's tight, and we only scheduled 45 minutes. And we'll see what happens. If worst comes to worst and we run to 12:15, is there anybody who would have a problem with that tomorrow?
Tomorrow? No, I guess I could. I'm supposed to have something at 12, but I'll put it off till 12:15.
Okay. I won't go any later than that because we have to be in.
Okay.
I have to be on the floor at 1. But the good news is today we get out half an hour early in order to prepare for a caucus
Yeah,
for the Democratic side anyway.
okay.